Hello all, I am Jessica and the topic for today's video is shares. So under this video, we'll be covering the meaning, the definition, allotment of securities, kinds of shares, allotment of shares, principles of allotment of shares, shareholders' rights, type of voting, shareholders' duty. Meaning. A share is a measure of the interest of a company's asset held by a shareholder. The memorandum and the articles of association of the company prescribe the rights and obligations of the shareholders. Further, a shareholder must have certain contractual and other rights as per the provisions of the Companies Act 2013. Definition. Section 2 subsection 84 of the Companies Act 2013 defines share as share means a share in the share capital of the company including stocks. Shares are considered as a type of security. Securities is defined in Section 2, subsection 80 of the Act, which refers to the definition of the securities as defined in Section 2, Clause H of the Securities Act 1956. According to Section 44 of the Act, the shares of any member in a company shall be movable property. It is considered to be transferable in the manner provided by the articles of the company. According to Section 45 of the Act, it mandates on all companies having a share capital to ensure that the shares of the company shall be distinguished by a distinctive number. This requirement does not apply where a share is held by a person whose name is entered as holder of beneficial interest in the records of the depository. Allotment of securities. Offers for shares are basically made when application forms are supplied by the company. It is considered as allotment when application is accepted. It is considered as an appropriate out of the previous unappropriated capital of the company. Consequently, where forfeited shares are reissued, it is not the same thing as an allotment. For an allotment to be considered valid, it shall comply with the requirements of the Companies Act and principles of the law of contract, that is regarding acceptance of offers. Now let us move on to the kinds of shares. According to Section 43 of the Companies Act 2013, the share capital of a company is of two types, that is, equity share capital, commonly known as equity share, and preference share capital, that is, preference share. Equity shares. Section 43, Clause A of the Companies Act merely states that equity shares are of two kinds, that is, equity shares with voting rights and equity shares with differential voting rights. Equity shares are also referred to as ordinary shares. They are one of the most common kinds of share. These stocks are documents that give investors ownership rights of the company. Equity shareholders bear the highest risk. Owners of these shares have the right to vote on various company matters. Equity shares are also transferable and the dividend paid is a proportion of profit. Equity shares are long-term financing sources for the company. These shares are issued to the general public and are non-redeemable in nature. Investors in such shares hold the right to vote, share profits, and claim assets of the company. The value in case of equity shares can be expressed in various terms like par value, face value, book value, and so on. One thing to note, equity shares are not entitled to a fixed dividend. The liability of an equity shareholder is limited to the amount of their investment. However, there is no preferential rights in holding. In India, we have equity shares that are issued with voting rights. Voting rights in common parlance would mean regular equity shares with normal voting rights, that is, one vote for one share. These voting rights allow investors to vote over various issues, the notice of which is normally sent to the shareholders in advance. Differential voting rights is used in the context of equity shares that are issued with the terms and conditions specifying that the shares are issued with differential voting rights. So, the basic difference between ordinary shares and differential voting right shares is with regard to the voting rights. Also, Sometimes differential voting rights carry higher dividend than normal shares. Now let us move on to the preference shares. Section 43B of the Act simply states what a preference share is. When a company is liquidated, the shareholders who hold preference shares are paid off first. They also have the right to receive profits of the company before the ordinary shareholders. The preference share is further divided into four. The first one is cumulative and non-cumulative preference shares. In the case of cumulative preference share, when the company does not declare dividend for a particular year, it is carried forward and accumulated. When the company makes profits in the future, these accumulated dividends are paid off. In case of non-cumulative preference shares, dividends do not get accumulated, which means when there are no future profits, no dividends are paid. The second type is participating and non-participating preference shares. Participating shareholders have the right to participate in remaining profits after the dividend has been paid out to equity shareholders. So, in years where the company has made more profits, these shareholders are entitled to get dividends over the above fixed dividend. Holders of non-participating preference shares do not have a right to participate in the profits after the equity shareholders have been paid. So, in case a company makes any surplus profit, they will not get any additional dividends. They only receive their fixed share of dividends every year. The third kind is convertible and non-convertible preference shares. Here, the shareholders have an option or right to convert these shares into ordinary equity shares. For this, specific terms and conditions need to be met. Non-convertible preference shares do not have a right to be converted into equity shares. The fourth and the last classification is redeemable and irredeemable preference shares. Redeemable preference shares can be claimed or repurchased by the issuing company. This can happen at a predetermined price and at a predetermined time. These do not have a maturity date, which means these type of shares are perpetual. So companies are not bound to pay any amount after a fixed period. Now let us move on to the issue of shares. When a company wishes to issue shares to the public, there is a procedure and rules that it must follow as prescribed by the Companies Act 2013. The money to be paid by subscribers can even be collected by the company in installments if it wishes. Now let us look into the steps and the procedure for the issue of new shares. First one is issue of prospectus. Before the issue of shares comes the issue of prospectus. The first step towards raising money for a company is done by issuing the shares. The prospectus is like an invitation to the public to subscribe to the shares of the company. The prospectus contains all the information of the company, its financial structure, previous year balance sheets and profit and loss account, etc. It also states the manner in which the capital collected will be spent. When inviting deposits from the public at large, it is compulsory for a company to issue a prospectus or a document in lieu of the prospectus. The company has to submit a copy of prospectus to the SEBI, whereas the private companies do not need to issue any prospectus. The prospectus of a company gives the information about the issuing company, name of directors, terms of issue, opening and closing dates of share issue, application fees and bank details for the deposit and minimum shares of the application. The second step is receiving applications. When the prospectus is issued, prospective investors can now apply for shares. They must fill out an application and deposit the requisite application money in the scheduled bank mentioned in the prospectus. The application process can stay open a maximum of 120 days. If in these 120 days minimum subscription has not been reached, then this issue of shares will be cancelled. The application money must be refunded to the investors within 130 days since issuing of prospectus. When the number of shares applied for is more than the number of shares issued, this is termed as oversubscription, while the number of applications for the issue of share is less than expected, then it is known as undersubscription. The amount paid for the application money must be at least 5% of the nominal amount of the share. 3. Allotment of shares. Once the minimum subscription has been reached, the shares can be allotted. Generally, there is always oversubscriptions of shares, so the allotment is done on pro rata basis. Letters of allotment are sent to those who have been allotted their shares. This results in a valid contract between the company and the applicant, who will now be a part of the company. If any applications were rejected, letters of regret are sent to the applicants. After the allotment, the company can collect the share capital as it wishes, in one go or in installments. The decision of the allotment of shares is taken by the company. Allotment of shares to its shareholders is called acceptance and is not possible until subscription. Minimum subscription is the minimum amount stated in the prospectus that is required to run the business. It is unlike that all the applicants will receive the allotment letter. Some applicants receive reject letter and their application money is returned to them. After allotment of shares by the company, the shareholders have to pay the remaining amount due on the shares according to the procedures mentioned in the prospectus. The minimum subscription amount of 90% of the issue is to be achieved by the company in 60 days from the date of closure of the issue. In case if it is not met, the company will have to refund the entire subscription amount. There is a relaxation of 18 days. For any delay after 78 days, the company will have to pay an interest of 6% per annum as a penalty. After the acceptance of shares, the applications become the shareholders in the company. Now let us move on to the principles of allotment of shares. First one, allotment of shares by proper authority. Allotment is generally made by resolution that consists of board of directors, but when the articles so provided, an allotment made by secretaries and treasurers will also be held as valid and regular. 2. Within the reasonable time. Allotment is basically made within a reasonable or specified period of time, otherwise the application shall lapse. The specified time frame of 6 months between application and allotment is held to be not reasonable. 3. Shall be communicated. It is primary that there must be communication of the allotment to the applicant. Posting of a property addressed and stamped letter of allotment is considered as a sufficient communication even if the letter were to be delayed or lost. 4. Absolute and unconditional. As per the terms and conditions of the applicant, the allotment must be absolute and unconditional. Thus, where a person applies for 400 shares on the condition that he would be appointed a cashier of a new branch of a company, it was held that he was not bound by any allotment unless he was so appointed. Now, let us move on to share certificate. A share certificate is a document issued by the company stating that the person named therein, the registered holder of the specified number of shares of a certain class, and they are paid up to the amount specified in the share certificate. The share certificate must bear the common seal of the company and also must be stamped under the relevant Stamp Act. One or more directors must sign in it. It should state the name as well as the occupation of the holder and the number of shares, their distinctive number, and the amount paid. There are a few rights which the shareholders have. Now let us look on to the shareholders' rights. The first one is appointment of directors. Shareholders play an important role in the appointment of directors. An ordinary resolution is required to be passed by the shareholders for appointment. Apart from this, shareholders can also appoint various types of directors. They are an additional director who will hold the office until the next general body meeting, an alternate director who will act as an alternate director for a period of 3 months, a nominee director. Apart from this, shareholder can also challenge any resolution passed for the appointment of a director in the general body meeting. 2. Legal action against directors. Shareholders can bring legal actions against the director by the rules laid down in the Companies Act 2013. They are any act done by the director in any manner which is prejudicial against the affairs of the company, any act done which is beyond the law and against the constitution, fraud, when the assets of the company are being transferred at an undervalued rate, any act done in malified manner. 3. Appointment of company auditors. Shareholders also have a right to appoint the company auditors. Under the Companies Act 2013, the first auditor of the company is to be appointed by the Board of Directors. Further, the shareholders at the annual general meeting at the recommendations of the directors and audit committee. The appointment is generally done for 5 years and further can be ratified by passing resolutions in annual general body meeting. 4. Right to call for general meetings. Shareholders have the right to call a general meeting. They have a right to direct the director of a company to call any extraordinary general meeting. 5. Right to inspect registers and book. As the shareholders are the main stockholders in a company, they have the right to inspect the accounts, register and also the book of the firm and can ask questions about the same. Next, right to get copies of financial statements. Shareholders have the right to get copies of financial statements. It is the duty of the company to send the financial statements of the company to all its shareholders either in a quarterly or in an annual statement. The last one, voting rights. Shareholders also have the right to attend and vote at the annual general body meeting. Every company registered in India should comply with the provisions of the Companies Act 2013. It is mandatory for every Indian company to hold an annual general meeting once in every year. The meeting can be held anywhere at the head office of the company or any other place as given by the company. At the meeting, there are various mandatory agendas which are to be discussed. Now, let us move on to the types of voting. The first one is voting by showing of hands. Every member present in the meeting has one vote. So, in this type of voting, shareholders vote just by showing of hands. The second type is voting done by the polling. In this type of voting, the chairman of the shareholders demand for a poll. However, in case of differential rights as to voting, a particular class of equity shares may also have the weighted voting rights. 3. Voting done by electronic means. Every company who has more than 10,000 shareholders has to put up a facility of voting through online means. Every member should be provided with the means of voting online. 4. Voting by means of postal ballot. Any resolution in the meeting can also be passed by means of a postal ballot. 5. Voting by proxy. A shareholder also has a right to appoint proxy on his behalf when he is unable to attend the meeting. Though the proxy is not allowed to be included in the quorum of the meeting in the case of voting, it is allowed to following a procedure mentioned in the Companies Act of 2013. Now let us see the duties of shareholders. Shareholders should participate in the general body meeting so that they can see and also can advise on the matters which they feel is not going good. Shareholders should consult on the matters of finance and other topics. Shareholders should be in touch with other members of the company so that they can see the work progress of the company. Shareholders need to pay the company when called for the payment of unpaid shares. Shareholders need to fulfill the objectives of Articles of Association. I think this video was interesting and informative. Thank you.